So were medieval duels legal? The short answer is yes, and also no. It really depended on what kind of duel you were talking about and when and where. It's not as simple as two knights getting angry and deciding to fight it out. The reality was a lot more structured and a lot more tied into the way people thought about justice, God, and honor. And to get a handle on it, you have to split medieval duels into two main types. First, there was the judicial duel, which is also called trial by combat. This was a formal legal procedure. It was a method used by a court to settle a dispute. It was a lawsuit, but with swords instead of lawyers. The second type was the duel of chivalry, or the affair of honor. This was more about a knight's personal reputation. It was less about the law of the land and more about the social code of the warrior class. They look similar on the surface, since both involved two armed men fighting, but their purpose and legal standing were completely different. Let's start with the judicial duel, because that's the one that was most clearly legal. For much of the Middle Ages, trial by combat was an accepted part of the legal system in many parts of Europe. Its roots go way back to the Germanic tribes that came to dominate Europe after the Roman Empire fell. These cultures had a strong tradition of settling disputes through fighting. When they converted to Christianity, they didn't just drop their old ways. They blended them with new ideas. The core idea behind the judicial duel was the judgment of God. People in the Middle Ages had a powerful belief that God was an active force in the world. They believed he would intervene directly to show the truth. A trial by combat wasn't just seen as a test of strength or skill. It was an appeal to a higher power. It was a way of asking God to point out the liar and protect the innocent. The winner of the duel didn't just win the fight, they were proven right in the eyes of God and the community. The loser wasn't just defeated, they were proven to be a perjurer, a criminal who had lied before God. This might sound strange to us. We think of justice as something based on evidence, witnesses, and logical arguments. But back then, hard evidence was often impossible to find. Imagine a dispute over land ownership where the documents were lost. Or an accusation of treason spoken in private with no one else to hear. In these cases, it was one person's word against another. The court had no way to know who was telling the truth, so they turned to what they saw as the ultimate judge. They let God decide. This wasn't a free-for-all. A person couldn't just challenge someone to a duel whenever they felt like it. The process was started in a court of law. An accuser would make a formal charge. The accused would deny it. If there was no other way to resolve the case, one party could request a trial by combat. The judge, whether a local lord or the king himself, had to approve it. He had to agree that this was a case where God's judgment was needed. Once approved, the duel was a highly regulated event. The court would set the time and place. It would determine the weapons and armor to be used. The fight would happen in a specially prepared area, often called the lists. Officials, known as marshals, would oversee the proceedings to make sure all the rules were followed. This was not a back alley brawl. It was a solemn, public ceremony, a key part of the justice system. The entire community might turn out to watch, not for entertainment, but to witness justice being done. So, in this specific sense, the judicial duel was absolutely legal. It wasn't just allowed, it was a tool of the state. Let's walk through how a judicial duel actually worked. It was a serious, formal process from start to finish. The stakes couldn't be higher. You weren't just risking your property or your reputation, you were risking your life and your soul. It all began in a courtroom. Let's say a man named Robert accuses another man, William, of a serious crime, like murder or treason. Robert stands before the Lord and makes his accusation. William, in turn, denies it completely. He calls Robert a liar. If there are no reliable witnesses and no clear proof, the court is stuck. This is where trial by combat comes in. Robert might formally challenge William to prove his claim with his body. He might even throw down a glove, a gauntlet, as a physical symbol of the challenge. If William accepts the challenge, he picks up the glove. By doing so, he is agreeing to defend his innocence in combat. But it wasn't automatic. The judge had to agree that this was an appropriate case for a duel. He wouldn't allow it for a petty theft. It was reserved for the most serious crimes, where the truth was hidden and the honor of the parties was on the line. Once the duel was approved, the preparations began. This wasn't just about sharpening swords and polishing armor. There was a deep spiritual element to it. Both combatants had to swear a series of solemn oaths. So they swore on holy relics that their cause was just and that they were telling the truth. They also had to swear that they were not using any form of witchcraft, sorcery, or secret charms to help them win. This was crucial. The fight had to be a pure test of God's will, not a contest of black magic. Any cheating would invalidate the entire process. The night before the duel was often spent in prayer and fasting. The men would attend a special mass. They were preparing themselves spiritually for what was, in essence, a sacred ordeal. They were putting their lives in God's hands, and they had to be in a state of grace to do it. On the day of the fight, a crowd would gather. This was a major public event. The combatants would enter the fighting ground, the lists in a formal procession. The marshals of the field were in charge. They would inspect the weapons and armor to ensure they matched what the court had ordered. They would read out the charges and the oaths one last time. The priest might bless the fighters and the field. Then the fight began. The rules could be very specific. Sometimes the duel was to the death. Other times it was until one person yielded or was unable to continue fighting. If one man surrendered, he was considered the loser. He had lost the case. The consequences for the loser were dire. If he wasn't killed in the fight, he was at the mercy of the court. Since God had shown him to be the liar, he was now guilty not only of the original crime, but also of perjury. The punishment was often immediate and brutal. He could be hanged or beheaded right then and there. His property would be forfeited. His name would be disgraced. There was no appeal. For God had spoken, and the matter was closed. The winner, on the other hand, was completely vindicated. His honor was restored, his claim was proven, and he was seen as an instrument of divine justice. Of course, not everyone could fight for themselves. What about a woman, a child, or a member of the clergy? The law had an answer for this: the champion. These groups, considered unable to fight, could hire a professional warrior to fight on their behalf. This introduced a whole new layer to the duel. Now, you weren't just betting your life on your own skill, but on the skill of a man you hired. The champion system became a profession in itself. These were skilled fighters who made a living by representing others in judicial duels. But the stakes were just as high for them. If a champion lost, he could also face severe punishment, sometimes having his hand cut off for failing in his duty. The person he represented would also lose the case and face the legal consequences. The whole system was built on the idea that God would strengthen the arm of the champion fighting for the just cause, regardless of who was the better warrior. While the state and the law often embraced the judicial duel, there was one powerful institution that had a huge problem with it: the church. From very early on, popes, bishops, and theologians were deeply uncomfortable with trial by combat. Their opposition created a major tension that lasted for centuries. A king might order a duel, while the local bishop threatened to excommunicate anyone who participated. The church's objections were based on a few key ideas. The most important one was that the duel was a form of tempting God. Theologians argued that you could not force God to perform a miracle on your schedule. A trial by combat was essentially demanding that God intervene at a specific time and place to reveal a hidden truth. This was seen as arrogant and presumptuous. God's will was mysterious and could not be commanded by a human court. To stage a duel was to test God, something the Bible explicitly warns against. Another major problem was, quite simply, killing. The duel involved violence, often to the death. This ran up against the commandment, "Thou shalt not kill." While the church accepted the idea of a just war, a prearranged fight to settle a legal dispute was a different matter. It looked a lot like a planned murder sanctioned by the court, even if the winner's cause was just he had still killed another man. The church also worried about the soul of the loser. If he died in the duel, he died in a state of sin, having participated in a forbidden practice. Finally, the church viewed the duel as a pagan relic. They correctly identified its origins in the pre-Christian traditions of Germanic tribes. They saw it as a barbaric custom that had no place in a civilized Christian society. True Christian justice, they argued, should be based on reason, evidence, and mercy, not on brute force. They promoted legal systems that relied on sworn testimony, inquests, and rational investigation. The duel was the opposite of all that. It was a throwback to a more primitive time. So what did the church do about it? They fought against it consistently for hundreds of years. As early as the 9th century, popes were condemning the practice. Church councils issued decrees forbidding it. The most famous and influential of these was the Fourth Lateran Council in 1215. This was a major event that shaped church law for the rest of the Middle Ages. The council explicitly prohibited clergy from having any part in judicial ordeals, including trial by combat. Priests were forbidden from blessing the combatants or the field of battle. The church used its most powerful weapon, the threat of excommunication. This was a terrifying punishment in the medieval world. An excommunicated person was cut off from the church. They could not receive the sacraments like communion or last rites. They were essentially an outcast, both socially and spiritually. The church declared that anyone who participated in a duel, and anyone who even came to watch one, could face excommunication. They also ruled that anyone killed in a duel should be denied a Christian burial. This meant their body could not be buried in consecrated ground, which was believed to put their soul in grave danger. This created a real conflict for people. On one hand, their king or lord might command them to settle a dispute by combat. It was the law of the land. On the other hand, the church was telling them that doing so was a grave sin that could damn their soul. This clash between secular law and canon law slowly but surely began to erode the legitimacy of the judicial duel. Kings and lawyers started to see the wisdom in the church's position. They began to develop more sophisticated legal methods. The rise of the jury system in England, for example, offered a rational alternative to leaving justice to a sword fight. Over time, the church's relentless opposition was a key factor in the decline of trial by combat as a legal tool. It didn't happen overnight, but the pressure was constant and, in the end, very effective. Now we come to the other kind of duel, the one that's probably closer to what most people imagine when they think of medieval knights fighting. This was the duel of chivalry, also known as an affair of honor. Unlike the judicial duel, this wasn't part of a formal court process to determine guilt or innocence in a criminal case. It was about something more personal, but just as important to the knightly class honor. The world of the medieval nobility was governed by a complex code of conduct we call chivalry. A knight's reputation, his honor, was his most valuable possession. It determined his social standing, his credibility, and his self-worth. An insult could be as damaging as a physical wound. If another knight called you a coward or a liar, you couldn't just ignore it. Your honor had been challenged, and it had to be defended. The duel of chivalry was the ultimate way to do that. These duels arose from personal disputes between nobles. It could be a quarrel over a lady's favor, a dispute on the battlefield about who captured a prize, or a simple direct insult. The purpose of the fight wasn't to ask God to reveal the truth in a legal sense. It was to prove, through courage and skill at arms, that you were worthy of your status as a knight. It was a way of washing away a stain on your reputation with blood. So, was this kind of duel legal? This is where things get murky. It existed in a legal gray area. It wasn't a formal part of the kingdom's justice system like trial by combat was. But it wasn't always illegal either. A king's attitude toward these duels was often complicated. On one hand, he was the chief knight of his realm. He understood and often shared the values of the chivalric code. He recognized that his nobles needed a way to settle their points of honor. On the other hand, he didn't want his best warriors killing each other over petty squabbles. A dead baron was a loss to the kingdom's military strength. As a result, the legality of a duel of honor often depended on the king's permission. Two powerful dukes couldn't just decide to fight to the death without consulting the monarch. To do so would be seen as engaging in private warfare, a direct challenge to the king's authority and his monopoly on violence. So, they would often petition the king for a license to fight. If the king granted it, the duel would be a massive state-sanctioned event. These high-level duels were orchestrated with incredible ceremony. Heralds, the official experts in chivalry and genealogy, played a key role. They would carry the letters of challenge and defiance back and forth. These letters were often long, elaborate documents, laying out the grievances in minute detail. The heralds would also help negotiate the terms of the combat, the location, the number of followers each knight could bring, and, most importantly, the weapons. The choice of weapons could be very specific, for example, fighting on foot with lances, swords, and daggers. These fights could be fought à outrance, which means to the uttermost. This was a duel to the death. Or they could be fought à plaisance, for pleasure or for sport. These were often part of a tournament and were fought with blunted weapons, with the goal of breaking a certain number of lances or scoring points, not killing the opponent. A famous example of one of these high-stakes challenges involved two kings. In the 13th century, after a war over Sicily, King Charles of Anjou and King Peter of Aragon accused each other of treachery and unknightly conduct. They agreed to settle their differences in a personal duel, a combat of 100 knights against 100 knights to be held in a neutral city. It was a massive international event. Heralds crisscrossed Europe and the arrangements were made. In the end, the duel never actually happened due to political maneuvering, but the fact that it was seriously planned shows how deeply embedded this idea of a duel of honor was at the highest levels of society. It was seen as a legitimate, if extreme, way to resolve a conflict between sovereigns. So the duel of honor was not strictly legal in the way a court case was. It was a custom of a specific social class governed by its own rules and traditions. Its legality was conditional, depending entirely on the consent of the ruling power. It was a form of regulated violence, tolerated and sometimes even celebrated by kings, as long as it didn't threaten the stability of the realm. By the end of the Middle Ages, the world was changing. New ideas about law, government, and warfare were taking hold. And as the world changed, the medieval duel began to fade away, though each type declined for different reasons. The judicial duel, the trial by combat, was the first to go. Its decline was a slow process driven by several factors. The church's constant opposition was a major one. For centuries, the church had chipped away at the duel's moral and spiritual legitimacy. By forbidding priests from participating and denying Christian burial to the fallen, the church made it a spiritually dangerous activity. This had a real effect on people's willingness to participate and on the willingness of courts to order it. At the same time, governments themselves were becoming more sophisticated. Kings and their administrators wanted more control over the justice system. They preferred a system they could manage, one based on inquests, evidence, and professional judges. A trial by combat was unpredictable. It left the outcome of a serious criminal case to chance, or to God, depending on your perspective. A strong king didn't want to rely on chance, he wanted to enforce his law directly. The rediscovery of Roman law also played a big part. Roman law provided a comprehensive framework for a legal system based on evidence and rational procedure, which was very appealing to the new class of university-trained lawyers and royal officials. People were also becoming more skeptical. The core belief behind the duel was that God would protect the innocent. But what happened when a notoriously wicked but strong knight defeated a famously pious but weaker man? Did that mean God favored the wicked? People began to question whether the winner was always the one in the right. Perhaps the outcome had more to do with strength, skill, or luck than with divine will. This growing skepticism undermined the entire foundation of trial by combat. By the 15th and 16th centuries, it had become extremely rare in most of Europe. It remained on the law books in some places for a long time, like a strange fossil, but it was almost never used. The duel of chivalry had a different fate. It didn't disappear so much as it transformed. The world of the medieval knight was changing. The development of gunpowder and new military tactics like disciplined formations of pikemen made the heavily armored knight on horseback less dominant on the battlefield. The feudal system, which had supported the knightly class, was also giving way to more centralized states with professional armies. But the ideal of honor did not die. It just adapted. As the military role of the aristocracy changed, their focus on personal honor and reputation became even more intense. The duel of chivalry morphed into the modern duel of honor. This is the duel we see in movies, fought with rapiers in the 16th century or pistols at dawn in the 18th century. This new kind of duel was almost always illegal. Kings and governments passed strict laws against it. They saw it correctly as a lawless practice that disrupted public order, yet it persisted for centuries. Why? Because it was socially necessary for the men of the upper classes. For an aristocrat or a gentleman, refusing a challenge would mean social ruin. He would be branded a coward and ostracized from his society. So, despite being illegal, the duel of honor was enforced by an unwritten social code that was often more powerful than the law of the land. So looking back, the question of whether medieval duels were legal is complex. The judicial duel was, for a long time, a perfectly legal and integrated part of the justice system, a solemn procedure designed to find the truth. The duel of chivalry occupied a grayer space, a custom of the warrior elite that was sometimes permitted and sometimes forbidden by kings. Both were products of their time, a world where law, religion, and personal honor were deeply intertwined. As that world faded, so did the duel, leaving behind a legacy that shows us just how much our ideas about justice have changed.